This morning in the chamber, we're looking at termination of employment. What must employers consider before ending a contract with an employee? And here with us today is lawyer Teresa Tabi, who's going to help us look at the legal angle of this issue. So very first question, when employers are handing out appointment letters to employees, should these letters contain the details under which the contracts can be terminated?
Well, generally, employers are not necessarily obliged or mandated to indicate the conditions under which an employment contract would be terminated. What is important is that the parties should be made aware of their right to terminate the contract. And given that there's a need for the parties, i.e. the employer and the employee, to have, before the termination actually happens, should have an idea as to what period of notice to be served to each other. So it's important that the period of notice is stated, but as to the conditions that would trigger a termination is not necessarily mandatory. But for purposes of prudent management and dealing with predictability, if you like, it would be advisable that, for instance, if you have a collective bargaining agreement, such conditions would be stated. But otherwise, generally, an employer is not mandated to state in the terms of, in a contract of employment, the conditions under which an employment would be terminated or the contract would be terminated. The overarching issue there is the period of notice that should be given, for which reason, if you're not able to meet that requirement, then you either, as an employee, then you forfeit your salary, or if it's on the part of the employer would have to pay the employee salary covering that period of time, if you like, that the notice was supposed to have been served.
Besides this, are there any laws governing termination of employment in Ghana?
Oh, yes, there are. Currently, we have the Labour Act, which was promulgated in 2003. That is the governing framework for labour issues or industrial disputes. Aside that, definitely the contract of employment would also have certain terms that would govern the relationship between the employer and the employee. But the thing about termination of contracts of employment is that whatever it is, it needs to comply with the law in force and also comply with the terms of the contract, and where applicable, a collective bargaining agreement.
One term that is normally thrown around when it comes to termination of employment is with immediate effect. Is that something that both employers and employees should be wary of?
It all depends on the contract, the terms of the contract of employment. Matter of which option you're going for as the party terminating the contract. If you decide to go by immediate effect, which is that you're not serving any notice, then you are willing to forfeit your salary. Similarly, if the employer is terminating the employee's contract without notice, then they are prepared to pay to the employee any outstanding benefits or benefits that have accrued, plus the remuneration for that period of time that they've worked up until the day of termination. So indeed, it is an option out there, but again, it's determined by the terms of the contract that both parties entered into. I would think that employers would be concerned about continuity of work, so that if one morning you come and your employee is saying, okay, immediately I'm leaving, there are issues about handing over notes, who's going to take over from that person and all of that. So indeed, those are the things that you should watch out for. But otherwise, indeed, it's an option open to both employer and employee.
There have been instances where an employer could give a 6-month contract to an employee, and before the 6 months is over, the employee decides to, I don't want to do the job again. If that employee doesn't give notice to the employer, what can be done under such situation?
The law requires that for any contract of employment that would engage the employee for a period of 6 months or more, it should be in writing. So clearly, there you have a contract that is in writing, so that you would expect that terms such as period of notice for termination would be in there. So you would have to go by those terms. So if you don't go by those terms, then it makes your termination, quote unquote, illegal then, because you're not going you're going contrary to the terms of the contract both parties agreed to abide by. So clearly, one party that feels aggrieved by that, if you like, unexpected termination could have an action against the other party.
Issues of discrimination do come in when it comes to termination of employment. Someone may feel that they were treated unfairly because of their sex, maybe because they are disabled or they are female. When these issues come up, is it up to the employee to prove that they were discriminated against, and which channels do they go through when such things happen?
Sure, very well. Whenever a party makes an assertion, that party would definitely have to prove that, especially when you are seeking redress. It could be from, in this particular case, talking about labor, it's either the court or the Labor Commission. The suggestion or the presupposition is that the person, i.e. the employee, is already in the employment of the employer, so that the discrimination didn't happen at the point of recruitment. It happened whilst they were working. So then you need to look at the pre and then the post, which is before things were working all right, but then you seem to have seen some difference in conditions being meted out to you. So then if you are trying to prove discrimination in that regard, you mentioned the case of a woman, for instance. Typically, these things come up when women become pregnant. So before they get pregnant, they are all up and about doing their job as usual. Nothing is happening. But then they get pregnant and perhaps they begin to slow down. They're sleeping on the job sometimes. And these things would happen. So then perhaps an employer would be like, perhaps it's about time we transferred you somewhere or did that. Clearly then you would be able to show that before I was pregnant, this was my schedule, this was how I was being related to with my employer and so forth and so on. But after becoming pregnant, this is what I have observed. So really it's an issue of the change in circumstances with respect to the employee. So you have to be able to show the differences, because it would be easier if the discrimination was observed at the point of recruitment, so that perhaps they're like, okay, we are taking in all males, so females are not being considered. But once you are in there, it presupposes that you had a certain pattern, but now things have changed. So you have to show what has changed. You understand? So there's that need for you to be observant, to be able to pick on those. Usually they are very subtle things, but you can tell that indeed this wasn't how it was before. And then there's an issue about incapacitation too, where somebody perhaps may have suffered an accident, and for that reason there's some level of incapacity. The question is the person still able to perform their duties for which they were employed? If yes, then sure, the person is carrying on their work and there's no need for a termination of employment. But where, for instance, the incapacity comes in and it affects their level of work or level of productivity, then perhaps there could be some issues that the employee may interpret as discrimination. You
sign a contract that states clearly what you're supposed to do on the job, but then you come in and you realize that this is completely different from what you were told. Under such circumstances, can you decide to leave without giving anyone notice whatsoever?
Whatever decision you take, it would have to be in compliance with the terms of the contract. So that if you decide to leave with immediate effect, then you are willing to forfeit whatever remuneration you would have accrued by the time you are leaving. There could be constructive, you could say something has happened that has made you forcibly leave the employment. So you could that could amount to constructive termination, not that you willingly want to leave, but you are being forced to because this isn't what you bargained for. You got into it and you realize that no, this isn't it. The terms have really changed. You agree to a certain terms and this isn't what is happening in reality. So there could be constructive termination, which would be that your employer has compelled you now to leave.
An employee is facing a criminal charge. Can the employer, even before the judge rules on the case, can the employer decide to terminate his contract with the employee based on the criminal charge?
There's the issue about whether or not the employee is in custody or the custody of the police by reason of the charge. or the person is not in custody, whereby the person is able to come to work and everything like that. Now, if the person is in police custody, clearly that person is not able to perform their function as an employee, for which reason you employ them. So that creates a certain imposition, legal imposition on the employee. They're not able to carry out their duties. And that, under the Labour Act, is grounds for fair termination. So if indeed that is the situation, yes, after a certain period of time, the person's contract with the employer is frustrated. The person cannot perform their role as an employee. So then that's a fair termination grounds. But where the person is not in police custody and is able to come to work, but is required to be reporting to the police station or to be appearing before the court, to have the case heard and all of that. Well, there are certain instances that the employer may want to suspend the employee for a period of time, pending the outcome of the investigation. And usually when that happens, the employee is put on a certain level of salary. So they're not taking their salary, the full salary that they're entitled to. It comes to a certain, usually it's half the salary that the person is entitled to, till after the investigations are done. And if the person is found not guilty, the person is reinstated. So there are two things that you look at: if a person is in custody or not, if a person is... And another thing too that is important here is that you need to know where the criminal charge is coming from. Is it an offense that was committed internally, i.e. in the organization, or committed outside? If it's internally, there will be internal procedures that the employer would have to go through or comply with, and that would typically involve suspension till after the investigations are done, and then whether or not there's a reinstatement or there's an actual termination finally, that, okay, you've been found guilty of that. And clearly we can't have you there, because one of the grounds for fair termination is proven misconduct. So where it's proven that the person actually committed this crime or this act, then yes, the person could be booted out.
Now, looking at unfair termination, can an employee then take the employer to court if he believes so?
Most definitely. An aggrieved party has two options: one, to go to court, or to the Labour Commission. The Labour Act has set up or established the Labour Commission to mediate or hear industrial disputes. So an aggrieved party could lodge a complaint with the Labour Commission, and the Labour Commission would interrogate or investigate these matters and make an order directed at whoever to do certain things. In some situations, it could be to compensate the worker, to reinstate the worker, and other things like that. So indeed, aggrieved parties, and most of the time if it's an employee, would have recourse to the Labour Commission or the courts. And so it's important that for any employer who is thinking or contemplating a termination, they need to be sure or convinced that what they're going to do is consistent with law, is consistent with the terms of engagement, i.e. the terms of employment contract they have with the employee. And also, if there's a collective bargaining agreement, it has to be consistent with that. Otherwise, they suffer, they are likely to be faced with civil suits.
All right, so that is the chamber, and we were discussing termination of contract. Hopefully, you are not going to be fired anytime soon.